I was asked to give a presentation about possible liabilities according to Ukrainian law. This is interesting for me as a foreign lawyer. I will be a lawyer of the Ukrainian Bar Association in a few weeks, but still I'm a lawyer registered in Munich. And I traveled 8 years the globe, you can say, to support international clients in terms of compliance investigations and questions, building up compliance systems. So for me, it's very interesting to give this presentation. And I hope for you it's at least entertaining. So the foreign lawyer is giving a presentation about Ukrainian law. I want to draw, have 4 sections, possible liability risk according to Ukrainian law. Very shortly, possible liability risk according to FCPA, UK Bribery Act, and the hot topic 2016. I hope I will get there. So although it's Ukrainian law and I was not educated in it, it's really interesting for me to dive into Ukrainian law and to see and to compare the Ukrainian law with other law regimes, not only the German one I know, but also US and also other law regimes worldwide. And it's very interesting for me, let you give this comment ahead, let me give you this comment, that the Ukrainian law, according to the law, fighting or dealing with corruption or money laundering or other issues, it's a very high standard law for me compared to other laws. I know it's a little bit sometimes ridiculous and you have laws which doesn't make sense. I heard that and I saw that myself. But according to this point, it's a very high law. So this is a compliment, but I also will have some comments which are not so nice, but let me come to that later. So I was checking the Ukrainian law about obligations companies have to build up, to establish, to run a good compliance system. And the law itself has some indications and some obligations to this point. And the first one is in the Civil Code, Article 92, saying that the directors have to act in the interest of the company in good faith and reasonably and within the limits of their powers. To give you an impression, the only law for a compliance system, building up a compliance system in Germany, is exactly the same sentence hidden in a law for stock exchange companies. That's it. So all the rest you have in Ukraine is much more than we have, for example, in Germany or other jurisdictions in Europe. Not in France, they now establish a new anti-corruption law, which is very sophisticated also. So what can happen if you violate this as a director? This is an individual liability possibility. You can face a possible full civil liability. According to tort law, you can have liability according to contractual law, and of course have to pay loss of profits. And I'm only talking about what the law is presenting. I'm not talking about the law enforcement. Law enforcement is a different chapter in this country, in our country, but it will improve, and we heard also from the first session that everybody's working on it. And I also, I'm quite optimistic. Since November 2014, I know the market, that this will improve, and this also means that when the law enforcement improves, the good law you have, you also have to check your risks you have as a company, because the law enforcement will improve. So, and what is new, according to Ukrainian law, there is a possibility of the shareholders also to file damage claims against the director. The next one is the law of Ukrainian joint stock companies. This we also don't have in many European jurisdictions. And it's about the obligations of officers also to act in the company interests and to comply with the requirements of the legislation, meaning to be compliant with the existing law. And the second one, the part 2, is about the officers of public company bodies, that they are liable to the companies for losses. So also here you have a liability risk according to the law when you don't have a good compliance system. The next one is the law on prevention of corruption, which is also unique. I don't know any or not so many European laws about that. And here you also have 2 liabilities. The one is the liability for legal entity, and the other is for the officers and founders. And I will not read all of it, but what is interesting is that it has a lot of general factors and specific factors you need to obey or comply with. And it even points out in the part 1 that the legal entity needs to have a compliance system. This also we don't have in Germany, according to my knowledge, for example. Of course, when you compare this to US law, it's of course another thing. Also, the European laws are now trying to adopt a lot of principles we know from the US side. But in this case, really, I have to make a compliment to the Ukrainian law. The officers and founders also are liable according to Article 61, Part 2. And also here, you face a possible full civil liability towards the company and third parties, because the directors always are in the risk when they do something wrong that they are liable to the company, because the company is also, they have the obligation to also file claims against directors to get the damage back, the compensation of the damage, not the damage back, but damage is done. And also third parties can claim damage claims. And then you have what is really interesting for me, this possible liability according to the Code of Administrative Offenses. This is very low, and for the lawmakers, when any lawmaker is here in the room, this is a room to improve, because from the public sector, the charges for not being compliant are too low, and it's more a joke than something you need to take serious as a company. Then you have the law on public procurement. Also there you have a compliance system, a need for a compliance system, and a standard and measures for detecting, fighting, preventing corruption. And what can happen if you don't obey that, you can get excluded from the tender, and also you have possible damage claims. What can happen to the individual itself beside that? So now we take a look at the criminal code and the administrative offense regulations of Ukraine. I will not read all of it, but when you look at it, the fines are pretty low. When you have a bribery case, fraud, embezzlement, anti-competitive actions from a proceeding point of view. The fines for anti-competitive action, later on I will tell you, can be much more for the company itself, but when you violate a procedural obligation towards AMC, then this will be pretty low, the fine. But what can be challenging is the imprisonments. What was interesting when I prepared this presentation, I asked an attorney of our law firm to give me a feedback about case law. I said, okay, check the case law, the database for case law. He came back and it was interesting for me to see case law doesn't exist so far. So you have only very, very few cases decided by laws, by courts and court decisions. But this will also come. This will also come. According to my experience, when I started to do compliance 8 years ago in Munich with Hogan Lovells, the awareness of the people, also in Europe, not only in Germany, was also pretty low according to compliance. But the awareness raised when we had court decisions in which the courts decided that the compliance officer or director needs to go to jail or needs to pay a big fine because some scandal came up. And we had a lot of scandals, not only Siemens and Mercedes, but okay. Then the next one, you can have, this is also a thing which I can assure you, you have corruption not only in Ukraine, you have it worldwide, so also in Germany. So the next fields are data privacy, data protection, money laundering, tax evasion, and environmental non-compliance. The last one is very interesting because it means when you violate the law for environmental protection, it can lead to imprisonment between 5 to 10 years. I don't know if you know that. So I had, for example, we had a client in Europe, I can't tell you the name, of course, a big chemical client, and we built up a compliance system for them, and the most important issue for them was to comply with the environmental protection laws, because this was the highest risk they had in many plants they were running. And what also these two slides show you, or I want to show you that, compliance doesn't only mean to focus on corruption. Compliance has so many fields. starting tax, employment law, money laundering, all the things you can see here, anti-competitive, and environmental law even, but also other things, product liability, product safety. So don't focus only on corruption. Now I want to talk about further possible liability risks. And this is also interesting for me. Product safety and product liability is really on a low level from a law perspective. When I compare that to European law is much more higher, sophisticated, more consumer friendly, and you can have much more higher risks as a company and as a director or board member when you act in a company producing, manufacturing products. But this will also change, because when you want to uplift or harmonize the Ukrainian standards with the European standards, the product safety and product liability will be one of the things which will be totally different. Because when you look at the fines we have here, I mean, this is a joke. This is even an invitation for the company to violate the law, because you have euro 250, euro 880 euro. I mean, this is not a fine, right? So when you are a manufacturer of high business and you have a return of, let's say, 1, 2, 3 million, then it's even worse to not to check that. But this will change. Then the further liability risk for companies. We have, of course, the liability risk for companies for the behavior of their employees. Meaning, if you have an employee who is violating a law, you as a company have the risk that you also face damage claims. Then the criminal code has some introductions of possible liabilities for companies where an employee is violating the criminal code, and then the company can, in addition, be charged according to these four possibilities. It goes from fining, getting an amount like a fine, penalty fine, but even liquidation, confiscation of property. But the requirements for that, I mean, I can't tell you because we don't have time for that. The law on protection of economy, this is a very important one, because there can be fines which really hurt. Meaning, when you do an anti-competitive action, this could even lead to a fine of 10% of yearly worldwide turnover. And we have similar laws in Europe also. And this is something the companies are really afraid of, because when you have a proceeding with the anti-competitive committee or authority in a country, then at least when you see this high liability risk, you will get out of this conflict not with you will at least have a bloody nose, and the fines are really high. So this is also in Ukraine a very high standard. I will make it very short. The next one, the enforcement of FCPA penalties in Ukraine. There are criminal and civil liabilities you can face. The criminal is the Department of Justice. The civil liabilities are enforced by the SEC of Washington. So, and on the left side you can see what can be from a criminal side of view. You can also have to pay, in worst case, twice of the benefit received from the payment or from the bribe or from anything. And this is much more harmful than the 2 million, as we see at the examples we have. I also have a slide on that. And beside that, from a civil side, you can have claims under False Claims Act. You can have a claim against any firm or any officer, director, employee, or agent of the firm, or even a stockholder acting on behalf of the firm. So, and you also have shareholder and derivative actions, which we have now included in Ukrainian law, which I told you before, also according to US law. Often when I am doing training for companies here in Ukraine, and I tell them, okay, this is a possibility, a liability risk for you, FCPA, UK Bribery Act, they say all the time, really all the time, I did this by now, they said, but they can't get through to us because we're in Ukraine. How can they catch us? How can they do it? And we heard already some things. So the basement for all these actions that can be addressed to Ukrainian companies and officers is a treaty between Ukraine and the US. And according to the treaty, I will not read all of it, they can act in connection, of course, with the help of the Ukrainian authorities, but they can act and they can come. And then you have some FBI guys here jumping around, making an investigation with the help of the authority of Ukraine. And this can even lead to fines, to freeze of assets, and also to imprisonment. So this is possible. These are some cases, I will not say all of them, and we also had a few. What is interesting about this slide is what I always try to tell, the FCPA is not only a law for the US companies. These are all non-US residing companies. And also it's not, how to say, I think we have a few focuses of the Department of Justice and the SEC, and one of the focuses are the CIS countries. And I can assure you that investigations in Ukraine will be more, and also that also from the pressure from outside about corruption and everything, the focus on Ukraine is pretty high, not only from the FCPA side. The next one is the UK Bribery Act. These are the offenses you can risk when you violate the UK Bribery Act in Ukraine. And also here you have up to 10 years imprisonment, unlimited penalty fine. This is also interesting. They thought they topped the FCPA. They say we have unlimited. And, but most of the case investigations, also the British authorities, investigation teams, they asked the US teams, Department of Justice, to help them, and the SEC. So you have to look to the US to check what is going on and how also Ukraine will improve in the next years. The enforcement of UK Bribery Act penalties in Ukraine, also there's a treaty between Ukraine and UK. The difference here is that you can't have, as far as I understand, the imprisonment. This is something you can't have according to the treaty. And also you have a treaty, European Convention on Mutual Assistance in Criminal Matters. And also here you can have support and everything, but no execution of imprisonment. The hot topic 2016, according to Anticorruption, is the publishment of the ISO DIS 37001. This will be an ISO standard worldwide for companies to implement and to establish, to run anti-corruption compliance system. And it's very interesting. I mean, they said it will be published in September. It's not published. Then they said in October, and now they say late 2016. But we hope it will be published this year. And also you can get a ISO certification by independent third parties that your compliance system is in the line with the ISO standard. But this is a very interesting standard because it is topping the FCPA guide standards. You have the FCPA, they published, the authority published a guide, FCPA guide, including some standard and principles, what you can do, how to establish a compliance system. And this standard is even topping on a higher level these principles of the guide. Thank you.